DeFiore, can you turn on your camera?
There she is. Okay. Mr. Breslow, you're up.
May it please the court. Brandon Brussell of Kynes, Markman, and Fellman, representing appellant Tracy Stout. Your Honors, may I reserve 5 minutes for rebuttal?
Sure.
As your Honors know, this is an appeal from a summary judgment in a premises liability case where Ms. Stout fell into what Mr. Hildebrand described as a manhole in his backyard while she was there to retrieve full-size fishing poles from a shed only a few feet away. The trial court erred when it weighed the evidence and decided for itself numerous material fact disputes, including the classic jury issue of breach. But where I want to start today is where the trial court also got it wrong, which is when it ruled that there was no evidence Mr. Hildebrand breached the duty to reasonably maintain his property merely because he warned Ms. Stout about the hole, which the trial court also deemed to be an open and obvious condition. I want to start with that error today for 2 reasons. First, that ruling's the heart of the summary judgment order, but directly contrary to this court's precedent. And 2, it's the basis for Mr. Hildebrand's main argument for affirmance. So as your Honors know, this court and others have explained that a warning about a condition or its obvious nature is not a basis for summary judgment on a duty to maintain claim like the one Ms. Stout brought, when there are circumstances from which a jury may find that the owner should still anticipate harm. So in that scenario, the owner must do something more than what Mr. Hildebrand did here, which is warn the invitee about the hazard.
Tell me, address what your comments in connection with Brookie versus Winn-Dixie, the first DCA case, where the fellow's walking back and forth carrying stuff. He sees these pallets, navigates around them twice. The third time he loses sight of them, trips and falls, and the court didn't find that, that he had knowledge of it, or was open, and it wasn't the responsibility of Winn-Dixie. Why isn't this like that?
This was not like that, Your Honor, for several reasons. One was that Brookie looked at first the danger of the condition, right? The pallet that was causing the injury and the fall outside of Winn-Dixie. And in that case, the pallet is a necessary commercial unit of the business. They said it was a legitimate aspect of a retail business economy. And that in itself was its first part of its decision about that not being a dangerous condition. And here, this is a hole. The case law, including Burton talks about essentially potholes and that there's signs of disrepair. Now, this isn't the pothole in the pavement. This is a hole that Mr. Hildebrand's dogs dug in his backyard. And it wasn't the first time that happened. This has
but the best evidence of that hole is that it happened in the early morning of that day. And while there's conflicting testimony about what he did about that hole, it seems to be consistent that he discovered it in the early morning on his way, just before he's going to work. And when he came back with her to retrieve the fishing poles, he said to her twice. The first time she said she didn't hear his warning. Second time she doesn't dispute that she heard his warning. So it's not like this is a hole that's been sitting there forever. She's been to his house before. They're friends. They're co-workers. He's got a fenced-in backyard, so he's protecting it from everybody else. The only reason she was there was to get these fishing poles. So, I mean, what more is he supposed to do? I mean, assuming the testimony that's least favorable to him, he saw these holes in the morning, didn't have a time to address it. He went to work. He came back later with her to get the fishing poles. I mean, is he supposed to have buried the hole before he went to work? Is he supposed to have barricaded it before he went to work? I mean, he didn't even really know she was going to come later that day. It was sort of decided she'd come get the fishing poles, and he twice said to her, "Don't fall in that hole." I mean, what more is he supposed to do?
There are 2 other things, Your Honor, that were argued below that he was supposed to have done or could have done in those circumstances that a reasonable jury could have found were unreasonable for him not to do. The first is that he should have never allowed her in the backyard. That is the simplest solution under this scenario. As a landowner of a private property, he could have said, "Don't come back there." In fact, that's what he said in his deposition. He told her, and there's conflicting testimony about that because Ms. Stout said she merely followed him into the backyard. She got there thinking that those fishing poles were in the garage, and he had placed them in the shed and led her back there. The reason the trial court didn't consider that evidence was that it viewed it not as a duty to supervise or a duty to monitor her or retrieve the fishing poles, which were all questions of breach because that would have been a reasonable response for him. The second thing he could have done was assisted her once she's back there. It's undisputed on the video that he opens the shed, walks far around the hole because he's not the one holding those fishing poles, and then leaves. And so the other reasonable response here would have been for him to stay in the backyard. But Your Honor, I also want to push back just a little bit on the fact about the timing of the hole, because even the answer brief cites cases and admits that that is a question for the trier of fact. Your Honor, there's this question or this discussion about whether or not he had.
Well, I guess, does it matter? Because the totality of the testimony, I believe, was he discovered it that morning. Now, there was some question about whether he said he buried it back that morning or whether he didn't. Does it matter? It's not like the hole's been there for weeks, and it's not like he's got an unfenced property that anyone can come in and trip in. The best testimony for you is that he discovered it that morning. And what happened after that, I guess, is, up for debate.
I think that debate is what's important here, Your Honor. He is a party in this case. And I understand there's case law that says when a statement and testimony is uncontroverted, that it can't just be speculation that what the party is testifying to is not true. But here you have a whole host of inconsistent statements by this interested party about what he did in response to finding the hole. He says he buried it that morning after she falls, and then he testifies that that didn't happen. He didn't have time. There's inconsistencies about who drove him to work. He's clearly, under Ms. Stout's testimony, which has to be viewed in our favor, he's driving himself back. And then all of that goes to his credibility. And so when we're talking about not the summary judgment standard and not weighing credibility and making those determinations, I understand that his testimony is the only one that can say, I discovered it that morning. And that would often be the case for a landowner, because there's not, surprisingly here, although there is security footage, we don't have any footage in the record that he put that the dog was buried it that morning, because it was a common problem.
Mr. Brussell, this case involves the trial judge granting a motion for summary judgment on the basis, and the motion for summary judgment argued that summary judgment was appropriate on the basis of legal duty. And both sides here agree this is not a duty to warn case because he did warn her, and we all saw that on the video. But in this instance, it seems like what you're saying, you just told Judge Morris some things that you think the property owner should have done. But I'm sure you would agree that we don't judge in the law of torts based on every possible thing that a landowner would need to do, every possible thing that they possibly could to protect and ensure an invitee's safety, right? I mean, I think you would agree with that.
I would agree with that, Your Honor.
All right. And here we didn't have a hole that was like a black hole, that was like a tractor beam that no one could walk in the backyard without being sucked into it, right?
I'm sorry, Your Honor, I'm not following that question.
We don't have a situation where we have an inexorable draw toward the hole that no one could ever avoid, right?
Yes, Your Honor, the hole doesn't have a gravitational pull. It's in front of the shed, yes.
So we just have a regular hole that dogs dug. And I mean, obviously we've all seen it. It's big. I'd love to see the dogs. I mean, they seem like pretty active burrowers. But in this situation, it almost seems as if your client would impose a duty on a landowner to not have dogs that could dig a big hole overnight. Because if they had that, then the existence of a hole for any length of time that someone could fall into, even though it was open and obvious, would be a basis for a duty.
Your Honor, can I respond to that? I didn't want to cut you off. So.
Please do, yeah.
Your Honor, no, that's not the duty that applies here. That's not what we're saying. What
Okay.
Our argument was below and is on appeal is that once Mr. Hildebrand has knowledge of this hole, he is the gatekeeper for his own property. And when he brings her in, invites her, leads her back to the shed where the hole is, and gives her the fleeting warning, watch out for the manhole, All of those things, and then leaves. All of those things are unreasonable. On top of the single issue of whether or not he had sufficient time to fill the hole or barricade around it, even if he learned about it that morning, because that is its own jury issue.
So in your view, a reasonable landowner would not allow anyone into their backyard if they know that there's a hole in their backyard? That's how you can maintain your duty as a landowner to keep your property in a reasonably safe condition for invitees. It's, in your view, if you know that there's a hole in your backyard, don't have anybody over.
I think it also depends, Your Honor. No, that is, again, not the extent of the argument, because it is going to be very fact specific on what that person is going into the backyard to do, which again, Mr. Hildebrand knew. And it's how big that hole is, which was a gaping hole in the video. And that also is something that we argued in the briefing, contradicts his testimony, because I would like to see the dog that can bury that overnight too, Your Honor. It is something that a reasonable jury could find under the totality of the circumstances, and that's what the case law requires, that he breached his duty to maintain his property. All of these are alternative arguments about his reasonableness, which goes to breach and not duty. The duty is established. He has a duty as a landowner to reasonably to maintain reasonably safe premises. And he knows what she's going back there to do. He lets her into the shed. He knows the collection of fishing poles are back there. He says he told her to wait and stop and he'll help her. That's not on the video either. And Your Honor, that's all situation that leads her to go into the shed, get the fishing poles, turn around, and unsurprisingly fall into that hole directly in front of the shed. And so he is the one who set up that scenario when he brought her into the backyard, when he left her there, and when he did not fill or barricade the hole. And that's where the trial court, when it says that it's deciding the legal issue of duty on summary judgment, overlooked the fact that those were reasonable responses. So, Judge Mo?
I didn't get that. Oh, yeah, she's frozen. We will recess. We'll recess for a few minutes while this happens, and I'm going to stop your clock, Mr. Breslow.
Thank you, Your Honor.
Judge Mo, it looks like you're back. We can't hear you. You're muted.
Right. So Zoom kicked me out and I lost Mr. Breslow very shortly after he started talking. If I could just ask you to repeat what you just said.
All right, okay. So I stopped his clock. Now I'm going to start it again. Okay, how's that?
Could you, because I don't know what I missed, could you give him enough time so that he can kind of catch up without?
Yeah, I don't know how far back we need to go. This is like watching television with my wife, who falls asleep and then says to me,
what I missed?
What did I miss? And I go, since when? You know.
Well, I lost you at 10:37. I said I lost the feed, so I would say about a minute before I left, it was frozen.
Okay, Your Honor. I'll try to backtrack to answer your question.
All right. Okay. All right. Go ahead. All right. You're back on the clock, and I'll give you a couple extra minutes if you need.
Thank you, Your Honors. Judge Mel, I'll go back to your question, which is about the exclusion of essentially any person from a property with a hole in it. And what I was saying was that that's not the scenario that's set up here. It will depend fact specifically on the nature of the hole, what that person and the invitee is in the backyard to do. And all of that was all of that was something Mr. Hildebrand knew going into this. He is the one who brought her back there to retrieve the fishing rods from the shed, knew there was a collection of them, opens the shed, and then leaves. And so it would be a jury question necessarily that due to where this hole is, how gaping it was, which is itself a reason to contradict or to counter his own testimony that was buried that night, that he knows that, and he acted unreasonably when he brought her back there in the first place. He acted unreasonably when he left her back there to retrieve these fishing poles that unsurprisingly led to her fall because this hole is in front of the shed, and ultimately acted unreasonably when he did not fill or barricade the hole. And I understand, Your Honor, that this was a legal question of duty where the trial court was deciding it, but that's the error we're alleging. Under the guise of duty, the trial court overlooks that these are necessarily breach questions about what he did that was unreasonable. There is no case, and Mr. Hildebrand does not cite any in his answer brief, that says that that exclusion is not a reasonable response, monitoring is not a reasonable response, and certainly that filling or barricading a hole is not a reasonable response under the timeline that's even uncontroverted here, if you believe his testimony, which the trial court wasn't required to do and shouldn't have done.
So, Mr. Breslow, it seems like part of your duty argument is that the landowner had a duty to monitor his invitee. Is that accurate? That's part of your argument?
Monitor was, I believe, may have worked its way into the trial court order or discussion at the hearing, but to essentially stay with her and make sure she did not avoid or did not fall into that hole while she's back there.
And that he should have led her away from the hole also?
That he stayed behind her, yeah, led her, whatever was going to be a potentially reasonable response to making sure she did not fall into the hole.
My recollection is that there were 4 aspects of duty that you talked about, that Hildebrand allowed the hole to exist, that he led her to the shed next to the hole, that he failed to monitor her and did not place visible warning barriers. Were you alleging that those were that he had a duty to not do those things, or that he did those things and therefore it was a breach?
He did that. So the duty is the duty to maintain reasonably safe premises.
Mm-hmm.
The breach was the failure to exclude her from the property, the failure to monitor her, the failure to retrieve the fishing rods, and the failure to fill or barricade the hole.
But you would agree that we wouldn't get to a discussion about breach if the trial court correctly ruled that you hadn't, that there was no genuine dispute of material fact, that the landowner did not have the duties that you were seeking to impose on the landowner under the law. We wouldn't be talking about breach, right?
Yes, Your Honor, and that's the trial court's error. That's it. This case is the trial court's order is almost exactly, if not exactly, like the one that was quashed in the Supreme Court case in Limones. The duty was never in dispute here. Neither party said that he doesn't have a duty to maintain reasonably safe premises.
So you believe that, again, getting back to the duty to maintain the property in reasonably safe condition, that the trial judge could not have ruled that as a matter of law, a property owner does not have a duty to maintain their property free of any holes in the yard?
I think that ruling would be either beside the point or error in this case, because that's not a question of duty. The duty here, I'm sorry if I'm repeating myself, Your Honor, I'm just trying to understand the question, but the duty here is the common law duty to maintain.
Mm-hmm.
When in the trial court's order, what it says is there's no duty to supervise, there's no duty to retrieve the poles. Those are the breach questions. And so the only question this court has to decide on appeal is there reasonable evidence is there evidence for a reasonable jury to find in the plaintiff's favor on a violation of that duty by Mr. Hildebrand? And our answer obviously to that is yes. And that includes the breach, the reasonable responses that Mr. Hildebrand should have taken, including exclusion, monitoring, filling, or barricade.
Mr.
Breslow, you're at your 5-minute rebuttal time, so proceed.
I'm just gonna forecast the question I'll ask you in your rebuttal time, which is, could you explain how you see the interplay between the idea of duty and the open and obvious doctrine in the context of this case?
Okay,
That's right.
so think about that, jot down some notes. We'll see you in a bit. Ms. DiFiore, you're up.
May it please the court, Dorothy DiFiore here for Paul Hildebrand. Mr. Hildebrand, like many homeowners in the state, has a dog, multiple dogs actually. He has three of them, one of which is a Chiweenie that does burrow quite aggressively. I have one, I can speak to that. The other was a German Shepherd also. And I believe what the questions today show is that the trial judge in this case sought to come to a reasonable balance of what kind of duties a homeowner in Florida with a fenced yard, so they've taken precautions against the general public. What is the duty of a homeowner when they have these dogs in a yard that's fenced, when they have not actually specifically invited people over? It's not like he was planning a barbecue that day, and they have someone who needs to access their backyard. And I think the discussion of this gaping hole or manhole, while it might show that this was a fairly deep hole, also shows that this was a large enough hole that everyone could see it. Not only that, it's very clear from the deposition, not the deposition, the video, that she saw this. She looked at it. She made a comment about the size of it.
Well, I think the facts of this are pretty well known to us. The trouble that I'm having at this point is we're here to review a summary judgment. And summary judgment is unusual in a negligence action because the assessment of reasonableness is generally a jury question. So that's the part that I'm having difficulty with, is because we have to address, is what he did reasonable? And that's usually a jury question. And Serrano versus Dickinson, the fourth DCA, basically, said this as good as I could say it, that this is typically a jury question, and summary judgment negligence actions are not common. I mean, because of this. Help me understand why this is not a stumbling block.
Absolutely. So you're right. They aren't normally a common thing in negligence cases because there's usually a lot of dispute about what happened and who did things. In this case, the trial judge's duty realized that a homeowner, and I do think we need to keep this in the context of a homeowner and not the commercial landowners that are the most. In fact, I couldn't find a single case that was similar at all against a homeowner. Has what they reasonably anticipate, or what they anticipate, and whether it's unreasonable to anticipate. And I think in this case, the judge's opinion is that it's unreasonable, or it's not reasonable for someone to anticipate that a friend of theirs who looked right at something would walk right into it. And it's a homeowner who has a visible situation in their yard that is not uncommon. It does have a reasonable duty to warn about it and to make sure there's some precautions. And when you tell someone to please watch out and they say okay, then it's not reasonable to anticipate that they're going to turn around and do it.
It's also under Florida law, duty is a question of law appropriate for summary judgment, correct?
Correct.
And that's not new. That's well established, right?
Right.
And could you discuss the interplay between the idea of duty as a question of law, and in this case, duty is the duty at issue is the landowner's duty to maintain the premise in a reasonably safe condition. Could you discuss that duty and the interplay between it and the open and obvious doctrine?
So the duty to maintain is the overall concept of a reasonably safe condition, which means that I think there were cases in which there was some open pipe that was sticking up and someone stubbed onto it and it caused a serious laceration. So we don't want big pipes sticking up. We don't want cliffs in our yard. We don't, things like that. You see the barricades, the handrails on boardwalks and things like that. I think one of the cases was a stairwell that needed a handrail on it so that it would not be an open fall off the cliff type of thing. So there's the obvious duty to make sure that in a reasonable situation, not every single situation, because there's also no duty to ensure and make sure that no one is ever hurt on the property, that it's reasonable. And that comes into a lot of considerations of the circumstances, which is why I think it matters that it's a homeowner. I think it matters that the yard is fenced. I think it matters that the dogs had only dug it that morning. I think it matters that it's all of those kind of situations. And then the open and obvious, it comes into play so that if it's there and you've said be careful, that is what's making it reasonably safe. In other words, the reasonable condition is including like look out for the pond. Look out for the gators on my pond, right? That's an open and obvious kind of danger. And so the warning is there, but the fact that there are sometimes going to be open and obvious problems that you can't eliminate immediately, that you can't do things right on time, that's not necessarily unreasonable. So it's about reasonable duty to maintain, and it says that to anticipate when the warning comes up. Do you have a reason to anticipate that the person won't heed the warning? And
let's say Mr. Hildebrand had a 14-foot alligator in the backyard of his house, and the backyard's as big as it is. It's no different. It's the exact same house. He keeps a 14-foot alligator back there. That would be an open and obvious condition. It's a pretty big alligator, so you could say, well, if the person saw it, but wouldn't you think in that situation, the question is, well, reasonably, there's an unpredictability to wild animals that you cannot under any circumstances let somebody in your backyard, if you keep a 14-foot alligator as a pet, no matter how open and obvious it is, because everyone knows, a reasonable person knows it's dangerous to let someone in your backyard. But here we have a static situation with the hole, right?
yes,
We have an open and obvious condition which anyone in their right mind can see. And in fact, the plaintiff in this case did see, right?
yes, exactly.
So are you arguing that it's appropriate to consider the open and obvious nature of the condition and the context of duty, because a reasonable person would assume that anyone can see it, therefore, if they see it, they can avoid it. It's not going to come out and get them, right?
That's exactly how I would love to have said it. So yes, that's the issue, and that's why I think the judge in this case was so focused on the duty and how the duty had been satisfied. Not that he didn't have a duty, but that he had met the duty because he had seen this open and obvious condition, made sure she was aware of it, that she saw it, that she appreciated that it was there, and in fact that she knew it was deep. And then and do not anticipate that somebody would just ignore that. As you said, the 14-foot alligator that you can't control, we don't expect someone to go out and see if it wants to eat some marshmallows. So we are not insurers of every person on our property. A landowner does not need to hold the hand. I think you referred to it as nannying the people on their property. So the idea that I can't let the person on if there's holes, so let me walk you around my yard, right? That's not reasonable. That's unreasonable. The idea that I should say to you, no, you're never allowed in my backyard, even though this was her idea, and there's no indication that he said, here, go over to the shed and get it yourself. She appears to have voluntarily chosen to do that while there was a lot of other stuff going on. So the judge is looking at whether a reasonable juror could, under these circumstances, believe that Mr. Hildebrand had not satisfied his duty. And that's where I think the judge was focused on duty, because Mr. Hildebrand, as the private landowner with a fenced-in backyard, a recent hole that was open and obvious and had been brought to her attention, did not have a reason to anticipate that she would, in her own words, I forget about it, or I misjudged because I'm backing out of a shed with my hands full. And the way she backed out of the shed, the way she engaged in the activities was not necessarily something he should have anticipated in light of that hole. And I think that's why the open and obvious is the significant issue here. It's not that there was no duty to warn. It's not that the open and obvious eliminates all issues in the case. It's that under the circumstances of this case, that the judge is comfortable that no reasonable juror would think that Mr. Hildebrand had breached his duty under the circumstances, under the exact video that we saw, in which seconds before she stepped into it, she acknowledged and discussed it.
Well, I want to press you on that point. You just said, and I want to see if you misspoke, you just said that the judge would say that no reasonable juror would conclude that he breached the duty. Did you mean that, or because while duty is an issue appropriate for summary judgment, like Judge Morris said, the issue of breach, I'm not aware of that being as clear of a question. So is the question in your mind that the trial judge concluded that no reasonable juror would conclude, well, actually, no, back up. Did the trial judge conclude that under the facts of this case, as a matter of law, the landowner did not have a duty to maintain a property that was free from holes? Or did the trial judge conclude that the issue turned on the fact that no reasonable juror could conclude that there was a breach?
Well, I think it was partly that you can't maintain a yard without holes, but I think it's also that you are a private owner and you have an isolated person in your yard on a single incident, so that the duty, again, is very, very limited in that situation. And I think that he found that no reasonable juror could believe that this landowner had not satisfied the duties in this case. So as you had a little struggle articulating it, I think that we all have a little struggle articulating it because it's negligence law, and sometimes there's very fine lines, and some opinions use wording that are not necessarily the exact phrasing, and same with judges and lawyers. So I think that that's more of a semantics issue than I don't think that this is the question of whether or not he breached the duty. I think the judge said that he did not have a duty to eliminate the holes. He did not have a duty to hold her hand and lead her to the shed. He did not have a duty to keep her out of the yard, and he did not have a duty to barricade the hole. And I think those are the duties that the judge was looking at, because they were arguing that they had to do these things in a way to satisfy their duty. And he's saying, no, that's not their duty. If that's all the questions, then I don't necessarily need to take up the court's time.
Okay, you never lose points by not using all your time.
I don't like to talk myself out of things.
Yeah, you're well. Okay, Mr. Breslow, you have 5 minutes to rebut.
May it please the court. Judge Mo, I want to start with your question about what exactly the trial court ruled on here. And I'll point the court to the record, page 445 to 446. And among a number of things the court finds about what a reasonable jury could do, it says the court finds that no reasonable jury could find that Mr. Hildebrand failed to maintain the property when the only evidence is that he discovered the hole in the dark immediately before leaving for work the day of the fall, and he warned her of the open, obvious condition which she commented on prior to it. So what the court did was make a finding or a ruling, generously, that no reasonable jury could find Mr. Hildebrand failed to maintain the property. And that is breach. And that's where the trial court erred in one of three ways, as I started the argument in my initial time, which was that the court erred when it limited the duty of this case, the duty to maintain, because it said that duty to maintain could not possibly include duty to supervise, duty to monitor, duty to retrieve the poles or essentially exclude her from the property. That's not the law. The law in this DCA and among Florida courts statewide is that duty is a question of law. There's a duty to maintain for landowners as their invitees. That duty is established. And what is the reasonable response for that duty? The Vogel case, the Knight case cited in our briefs, is a question for the jury, whether the landowner has taken sufficient precautions. Going to Judge Mo, the question you left my initial time on about the intersection of duty being a question of law and the open and obvious doctrine. Generally speaking, and this is again is the case law we're saying that this court should follow, is that the open and obvious doctrine, or even a discharge of the duty to warn, so actual knowledge, does not discharge the landowner's duty to maintain when, as my friend pointed out, there is an anticipation of harm. And here, what was not reviewed by the trial court or not considered by the trial court, although argued below, and my friend did not bring up on the other side, is that this is a case where there was foreseeability of harm, notwithstanding the warning. And there is evidence to support that. The evidence being that it was undisputed Mr. Hildebrand knew what Ms. Stout was on the property to do, which was retrieve full-size fishing poles from his shed. And Ms. Stout testified herself that she was focused on maintaining the fishing poles when she exited the shed so they didn't break. All of that was known by Mr. Hildebrand going into this scenario where he still brings her back there, still brings her near the pole. And the intersection of this foreseeability analysis and the intersection between knowledge and obviousness and duty to maintain all comes down to comparative negligence. That's what a through line of cases from this court and statewide have said. It comes down to comparative negligence. And so when this court is deciding this case, it's reversed based on settled law. There's nothing here that Mr. Hildebrand has pointed to that warrants summary judgment on similar facts, that says the duty to maintain can ever be limited in such a way like the trial court did here. And so, Your Honors, for those reasons, we ask that the court reverse the trial court summary judgment order, and because it failed to consider the multiple ways that Mr. Hildebrand did breach his duty to maintain reasonably safe premises, and the summary judgment order should be reversed and the case remanded for a trial on the merits. Thank you.
Okay, thank you both very much. In order to leave our virtual courtroom, I think you know the drill. You need to click the leave icon.